Hello and welcome to Topic 12, Lecture 1. And in this lecture, we're going to be learning about the right to counsel. So what are we going to be covering in this lecture? Well, first we're going to do an overview of the Sixth Amendment and the trial rights that are associated with the Sixth Amendment. And then we're going to focus on the right to counsel in particular and look at the key cases associated with expanding the right to counsel. So let's go ahead and get started. So what we've been learning about in the last few chapters, in the last two chapters, is we're learning about the rights of those who are accused of crime. And so here we're talking about criminal cases. And I just want to remind you that when we're talking about criminal cases, we're talking about that criminal proceedings are state versus the individual, okay? And so if an individual is charged and tried for a crime, let's say in the state of Wisconsin, then it would be Wisconsin versus Smith, right? That the state is the one who is prosecuting the individual. Civil cases, it's individual versus individual or corporation versus corporation. It's private entity versus private entity. But in criminal cases, it's the public entity of the state that is defending its laws and prosecuting those who violate the law. And so, as we talked about in the last lecture, that, the state is mighty and the individual is less mighty, and particularly those who are accused of crimes are even less mighty, less powerful. And so we know from last week that that's why so much of the Bill of Rights is dedicated to those who are accused of crime, because it's in these moments where the state has a lot of power and can really abuse its power as it relates to criminal prosecution. And so last week we learned that the Bill of Rights places limitations on how the government can make a case against an individual, right? And so last week we learned about the Fourth and Fifth Amendment that are related to evidence and investigation, how a person can be searched, what kinds of searches are constitutional, whether or not a person could be forced to speak to the police, right, to testify, confess, or to be interrogated by the police. And so we know that the Fourth and Fifth places limitations on the investigation of an individual. This week, we're going to be taking a look at the Sixth and the Eighth Amendment, because it's the Sixth and Eighth Amendments that deal with protecting the rights of those accused of crime once they've been charged. And so once charges are made and the investigation is complete, the Bill of Rights provides protections for individuals charged with a crime, trial rights in the Sixth, and punishment rights in the Eighth Amendment, and also bail as it relates to Eighth Amendment excessive bail as well. So that's what we're going to be looking at in the two lectures that we're going to be having this week. One looking at trial rights and the other looking at the Eighth Amendment and the application of the death penalty as a sentence for a criminal offense. So as I mentioned at the beginning, we're going to focus in this lecture primarily on the right to counsel and what the Supreme Court has said about the right to counsel. However, I want to make sure that we read the Sixth Amendment and we do a quick overview of all the rights that are in the Sixth Amendment as it relates to trial rights, in particular because you're going to be reading other cases in the textbook about the Sixth Amendment above and beyond the right to counsel. So here is the Sixth Amendment. It states that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So that's what the Sixth Amendment says. Let's dig in and look at what those different clauses within the Sixth Amendment, what those mean, and what you'll be learning about in the textbook this week. So that's the Sixth Amendment. Let's look at how the Sixth Amendment plays itself out on the ground in terms of jury and trial rights. So the Sixth Amendment says that the defendant has a right to a speedy and public trial with an impartial judge. And if it's a jury trial, and you don't always have a right to a jury trial, but usually in most jurisdictions, it's if you're being charged with a serious crime, you have a right to a jury trial. You also have a right to an impartial jury if it is, in fact, a jury trial. You can also waive your rights to a jury trial, and you can just have a bench trial. But that's what the Sixth Amendment says about, public trial, speedy, impartial judge, and that you get an impartial jury if it's a jury trial. So you're going to be reading a lot of cases in the textbook that deal with answering the question of, okay, well, what constitutes a speedy trial? Barker, so you'll be reading about Barker v. Wingo, a 1972 case that sort of gives us an insight into what constitutes a speedy trial and to what degree the government can violate, or to what degree the government can wait to give you a speedy trial, and whether or not that violates the Sixth Amendment. You're also going to be looking at the how we got an impartial jury and what constitutes the calling of, like, what are some of the steps that are in place in order to make sure that we get an impartial jury. And so, you're going to be reading about concepts of venire and voir dire. Venire is the jury pool. Voir dire is when the lawyers, both the prosecutors and the defense attorneys, begin questioning jurors and basically picking who they want to be on the jury. And that, as you're going to be reading in the textbook, that there, when it comes to voir dire, the selection of the jury members, that you want to make sure that each lawyer, like, if there's a reason why somebody shouldn't be on the jury, then that you can say we don't want that juror on the jury because there's a reason. It's for cause that we are not letting them sit on the jury. So let's say it's a case about figuring out whether or not a police used excessive force, and somebody in the jury pool is his brother or sister is a police, that might be a conflict of interest, and so you might want to not let that person on the jury because of cause. But there are also challenges that are known as peremptory challenges. And those are the challenges where you can just dismiss a juror, but you don't have to give a reason. There doesn't have to be a cause for it. And so you're going to be, so there are certain rules that are used to get a jury, and questions have come before the court about the way we dismiss jurors, whether or not that violates the Sixth Amendment's demand for an impartial jury. So you're going to be reading a case, Baston v. Kentucky, about a prosecutor, a man who is charged with robbery, and a prosecutor and he's black, and a prosecutor who gets rid of all, or dismisses all the jury members who are black in their peremptory challenges, not for cause, but just that they didn't want these people. And so we'll find, that the court says that that's a violation of the Sixth Amendment demand for an impartial jury. You'll also be reading about Shepard v. Maxwell, which is about the role that the media plays in influencing the jury pool. Okay. And so keep, these trial rights in mind as you're reading the cases. Other trial rights that are both implied from the Sixth Amendment or explicitly stated are, you have the right to be competent at a trial. And so you really cannot have an impartial, fair, public trial that if the person who's being charged with the crime is not competent. And the reason for that is that, a person who is being tried for a crime, they have to be competent enough to help in their defense. And if they are incompetent, then they can't participate in their defense. And that basically makes a mockery of the point of a jury. You have the right to be present at the trial, that you have the right to confront witnesses. And so you will read about that. That's called the Confrontation Clause in the Sixth Amendment. And so basically the prosecution can call witnesses to make their case, but the defense has a right to question those witnesses, to confront those witnesses in a courtroom, and to engage in cross-examination. So you're going to be reading some cases about the Confrontation Clause. That is the defendant getting an opportunity to cross-examine the prosecutor's witnesses. And then also that the Sixth Amendment tells us that there's a compulsory process, the Compulsory Clause, which basically says that the defendant has the right to secure witnesses in their favor. So while the prosecution can bring in witnesses to make their case, and the defendant has a right to confront those witnesses, that the defendant also has a right to secure witnesses in their favor. In other words, they have the power to subpoena a person to testify for the defense. And again, these are all topics that you'll be learning about through the cases that you are reading about in this chapter. All right, so that brings us to the Sixth Amendment's right to counsel clause. And, I don't want to say that one right in the Sixth Amendment is more important than any of the other rights. However, I think a pretty good case could be made that the right to counsel is perhaps one of the most important rights of the criminally accused. Because, a trial is a place where a lot is on the line, and that you want to make sure that the individual who's charged with the crime has the assistance to make the best possible case in their defense as possible. And that's important not only because everybody deserves a defense, but it's also important because when we convict somebody, we want to have a high confidence level that they are actually guilty as charged, right? It's easy to convict people if they don't have good counsel. It's easier to convict people if you don't have good counsel. But if you have good, robust counsel, that basically means that when we do convict somebody, that we have more confidence that it was the correct decision. And so keep in mind that criminal defense attorneys do much more than just represent the accused at trial. Very few cases go to trial, right? 90% of cases where people are charged, they end up not exercising their Sixth Amendment right to trial. Rather, they plead guilty. They enter a guilty plea, waiving those rights to trial. And they do that because they could very well be guilty, and that oftentimes prosecutors will say, hey, we'll reduce the charge and we'll ask for a lesser sentence if you enter a plea of guilty. And so that doesn't mean that criminal defense attorneys are not important, right? They're very important during trial, but criminal defense attorneys do a lot more than just represent a person who's accused of a crime at trial. A lot of hearings take place before a trial. And so that it's important that you have counsel when you're arraigned, that is when you're told of the charges and when bail is set. If you decide to plead guilty, it's important to have effective counsel so that plea bargaining, that the counsel can get the best deal possible for you. And so, defense counsel is really more important. It's important not just at trial, but it's really important throughout a lot of the criminal justice process because defense attorneys represent their client from the moment that they are beginning to be interrogated by the police at arrest all the way through their first appeal. Okay, so keep that in mind as you're thinking about why the right to counsel is important. It's much more than just the right to counsel at trial. So initially, the right to counsel clause in the Sixth Amendment was interpreted as a thou shalt not on government. And we've talked about that throughout the course of the semester. That is that, the Bill of Rights is basically placing a restraint on the power of government. And that's how the assistance to counsel clause was initially interpreted. And so the way it was interpreted is that the state is forbidden from preventing you from having legal counsel. But you have to pay for your legal counsel. You have to provide your legal counsel. It's just basically saying if you bring legal counsel to help you in your assistance to your defense, state can't pass a law saying you can't do that. In other words, you can do it, but the state is not obligated to give you an attorney. The shift in terms of the interpreting the right to counsel clause in the Sixth Amendment, that changes a lot in the 20th century, as we see. It's not just a prohibition on government action, but that it's a right that you should be able to realize. It's a right that you should be able to exercise. Because if you have a right to bring counsel, but that if you're poor and you can't afford counsel, it's a pretty meaningless right. And this was particularly the case, this shift of thought, when it came to people who were accused, charged, and tried for crimes that had very significant or severe outcomes if found guilty. And that brings us to the first right to counsel case that we're going to be talking about, which is Powell v. Alabama. So let's talk about the famous case, Powell versus Alabama, which is also known as the Scottsboro Boys case. This is one of the first cases that the Supreme Court hears that really explores the question regarding the scope of the right to counsel in the Sixth Amendment. Keep in mind that this case is about a certain kind of defendant, and it's a case that's about a certain type of case, charge and penalty. Okay, and so as your textbook sort of talks about that this is really sort of the first step in understanding the right to counsel, right? But it doesn't shut the door on a further expansion of the right to counsel. And that's basically the Powell opens the door regarding the right to counsel when it comes to charges wherein the penalty can be the penalty of death. But then it opens the door to say, well, maybe we can expand it more in the future, which in fact the court does. So let's go ahead and take a look at the facts of this case. So let's talk about the facts of the case. This is a famous case. A lot of people think that it was really, began a spark for the civil rights movement that, began in the 1950s and 60s. That the book To Kill a Mockingbird, that Harper Lee says that, that it was this case that sort of, inspired part of her writing for that book. So this is a famous and historic case that you might know about. And what it's about is, notice the time period, it's 1932. And so this case is about young people who during the Depression rode the rails, took to the train cars in order to find work. Okay. So a lot of businesses were closed. A lot of factories and manufacturing was, closed. And so young people looking for work, trying to make ends meet, would get on the trains and go from city to city looking for work. And that's what this case is about. So this is a case about 9 African-American young boys and young men who ranged in age from the age of 12 to 20, and that they are riding a train car from Tennessee into Alabama looking for work. And on the train car is a group of white boys, men about the same age, and 2 white women. One is 21 and one is 17. A fight breaks out on the train car, and then it results in the black kids throwing the white kids off of the train car, and the 2 white girls are left behind in the train car. Okay, and so the group of white kids who was thrown out, they contact the cops, basically say that that the black kids were responsible for them getting, starting this fight. And so as the train car pulls into Alabama, sort of a posse and cops are there to basically take the Scottsboro boys into custody. And it's called the Scottsboro boys case because that's where they're taken to be tried, the seat of Alabama, Scottsboro County. So they're taken into custody, and then it gets worse. The 2 white girls claim that the boys had raped them on the train, and so they are charged with rape, which is a capital offense at this time period. That if you're found guilty for rape, you can be put to death. The judge basically assigns them counsel, but the counsel is any lawyer working in the Scottsboro area. No lawyer steps up to help them. They set the trial for like 6 days after the arraignment, and so they do get a lawyer, but he's not from Alabama. He doesn't know Alabama state law. The trial it happens quickly, and that 8 out of the 9 of the Scottsboro boys are found guilty and sentenced to death. And so that's the facts of this case. The girls, one of the 2 girls later recounted in the retrial saying that they weren't raped. There's a long sort of history. You can read about it in the textbook. But the bottom line here is that a group of boys, young men charged with rape, didn't have proper counsel, convicted, found guilty, and 8 out of the 9 sentenced to death. So let's look at what the question before the court is, and let's look at how the court ruled in this case. So the question before the court in Powell v. Alabama is, do indigents have the right to counsel in a capital case? And in a 7-2 decision, the Supreme Court says yes, that indigents in capital offense cases do have the right to counsel. The reasoning was that defendants should have a fair opportunity to secure counsel. That didn't happen in the case, that the defendants here did not have aid of counsel in any real sense. The judge said, hey, any lawyer can help these folks out. Nobody stepped up that wasn't true counsel. And then when somebody did step in, they weren't even from the state. So again, not in any true sense, there was no counsel. The failure to give counsel in this case is a denial of due process. And that basically they say we're not deciding whether this pertains to all criminal prosecutions, only in certain circumstances, capital offenses, where there's public pressure, because as you read in the textbook, there was a posse that was like developing outside the jail cell where the Scottsboro boys were held, like demanding that they be, like lynched, that they were young, uneducated, and inexperienced defendants. So it's a really sort of narrow ruling. You're sort of saying, yes, you have a right to counsel in these certain circumstances. Not everyone agreed. Two dissenters said the defendants did have counsel from Tennessee, somebody who stepped in, and that if they needed more time, they should have asked for more time to prepare. Okay, so basically said, hey, they did have counsel, but the majority, disagreed, saying that it really wasn't, by any practical measure, true and effective counsel. So the decision in Powell was quite limited. That yes, that counsel must be appointed in cases with unusual circumstances, where the penalty is death, where there's public pressure to convict, where there are young and uneducated defendants. In those sorts of instances, counsel is mandated. And so the verdict in these initial trials was vacated, and as you'll read in the textbook, the Scottsboro boys were retried. But even with counsel, it did not result in good outcomes. So make sure that you read about that in the textbook, about sort of the long history that is behind this case that continues on even after this decision. Another important aspect of the Scottsboro boys case is that in their next trial, the jury was an all-white jury, right? And so then the Supreme Court kind of revisited and said, no, that segregation, not allowing blacks to serve on juries, is a violation of the Due Process Clause. And so there's more rulings that come out of Powell as well. But Powell does not answer the question as to whether every defendant has a right to counsel. As I mentioned before, Powell sort of opens the door on the right to counsel with a future of potentially expanding it. But it's very narrow in its scope, and it doesn't answer the question about, okay, does the right to counsel apply to all defendants? That question is answered fully in Gideon, and that we get insight into Gideon by looking at the cases that lead up to Gideon versus Wainwright. So let's take a look at that now. So following Powell v. Alabama, more questions come to the court about the extent to which the right to counsel clause applies to criminal defendants. And soon after Powell, case Johnson v. Zerberist comes to the Supreme Court. And the question in that case has to do with the right to counsel in federal cases. And so in this case, it was an indigent a defendant. Indigent means unable to pay for their defense, poor, and that they were being tried for a federal offense. Okay, and so the question came before the court about whether or not those who are being tried for breaking federal law, whether or not the Sixth Amendment right of counsel applies to those cases. And in Johnson v. Zerberist, they said, yes, if you are being tried for a federal offense, that you are entitled to the right to counsel. But the question is, okay, well, if you're tried for a federal offense, you get the right to counsel. What if you're being tried for violating a state criminal law? Keep in mind, the vast majority of criminal law does not come from the federal government. It comes from the states. Okay. So, I mean, I teach criminal justice, and, when you look at the number of people who are in federal prisons versus the number of people who are in state prisons, like so many more thousands, hundreds of thousands of people are in state prisons, not federal prisons. Federal prisons is like less than 10% of the prison population. And that's like why am I telling you that? I'm telling you that because it's like the vast majority of criminal law and criminal prosecutions and criminal penalties are work their way through the state side of the system. Okay, so even though Johnson v. Zerbis is good for the right to counsel, expanding the right to counsel, it really doesn't apply to a lot of people because most people aren't charged with a federal offense; they are charged with a state offense. And so the question comes to the court in 1942, so soon after Johnson. Then those who want to see the expansion of the right to counsel say, you have a right to counsel in federal cases. What about in state cases? And so Betts v. Brady is the question is should the ruling in Johnson apply to the states? And the Betts v. Brady case is about Smith Betts. He's charged with robbery. He's poor, he's white, he's uneducated, but he can read. He's literate. He asks the government for a lawyer. He's denied. And that he is convicted and found guilty of the robbery. And so he appeals and he says, wait a second, I asked for counsel. I didn't get it. My Sixth Amendment rights have been violated. In a 6-3 decision, the Supreme Court disagreed. They said that the right to counsel is not a fundamental right and that Betts was not like Scottsboro's defendants. He was not helpless. He wasn't illiterate. He wasn't facing the death penalty. And so, keep in mind, there's a couple of things going on here. I think one major thing is the question about what rights should be incorporated to the states. And that the right to counsel, remember that when we incorporate rights to the states, we're asking ourselves, are these fundamental rights? That you can't have ordered liberty without it, okay? And that the Supreme Court in 42 said, nope, the right to counsel, you can still have ordered liberty without the right to counsel, okay? So from 1942 until the 1960s, that we had basically a 2-tier system. In federal cases, you got the right to counsel, and that's because, hey, the Bill of Rights is seen as a prohibition on the exercise of the federal government. But that it's not until Gideon versus Wainwright where the Johnson ruling is applied to the states. So Gideon versus Wainwright, a very landmark, important case. And, what makes this case interesting isn't so much the facts of the case initially, but what happens after Clarence Earl Gideon is convicted of breaking and entering into a pool room in Florida. So Clarence Gideon is a lot like Betts, that he is charged with a relatively minor crime, breaking and entering into a pool room and stealing money out of a jukebox. And that he is charged and that when he goes to trial, he is asked for counsel and he's refused counsel because it's not a capital offense. And like Betts, Clarence Gideon is very similar. He's poor, he's uneducated, he's a white man, but he's literate, right? And he's able, and so he, the courts say that, hey, you should be able to defend yourself. He tried to defend himself, but he failed, and he was convicted of breaking and entering. What's interesting about the case and why that, I put on my magic pen there and we have this famous document right here, that when Clarence Gideon in prison, he uses that time to study the law and that he actually submits a writ of certiorari that is in form of papyrus, right? The form of papyrus. Remember we learned about that earlier in the semester, that usually that it has to be in all this strict guidelines about how it's submitted. But the Supreme Court makes exceptions for people who are poor. And so Clarence Gideon wrote his writ of certiorari on prison paper. He sent it to the Supreme Court and they agreed to hear his case on the right to counsel. So let's see what the question before the court is, and let's look at how the court ruled. So the question before the court in Gideon versus Wainwright is, should the court's holding in Betts v. Brady be reconsidered? So this is a case about stare decisis, right? That we have case from the 1940s and that, 20 plus years later, that the court is asked to reconsider its ruling in Betts. And so that should the ruling in Betts be reconsidered? And the Supreme Court says yes. that it should be reconsidered and overturned, and indeed it was. That they say that in Betts v. Brady, they said that the right to counsel was not a fundamental liberty. The Warren Court disagrees that the right to counsel is a fundamental right and thus must be incorporated to the states. They say that Betts was wrongly decided because it did not fully consider court precedent and Powell. And so that basically, they basically said that there were things in Powell that set the seeds for this expansion of the right to counsel, and that the right to counsel is, in fact, a fundamental right. And so they said that it was wrongly decided because it didn't consider the precedent that was outlined in Powell. They look to polling jurisdictions, and they basically say that 22 states agree that 22 states had expanded the right to counsel for everybody, and that using that information, the Supreme Court's like, we need to get in line. And that the claim that counsel is a fundamental right is supported by the fact that the state spends a lot of money on trial and prosecuting individuals, and so does a defendant if they are able to do so. So that because defendants who are accused of a crime spend the money, if they have it, to defend themselves, and the state spends a lot of money in prosecuting, that same right should be extended to the poor, to the indigent. So why is Gideon important? Well, Gideon is important because it's another example of the Warren Court's revolution in expanding the rights of those who are accused of crimes. That is also important because it shows the importance of a dissent. Throughout the semester, we've noticed that when the court rules a certain way, oftentimes there's a dissent in the ruling, and then that dissent is picked up to become a future majority ruling. And that was the case in this case. Hugo Black dissented in Betts, and that dissent became the basis of the court's opinion in Gideon, right? So that the court will look back at dissents and use them in basically forming new rulings. It's also important because it had a huge impact on the criminal justice system in the United States. Whether you know it or not, you know it now. The vast majority of people who are charged with the crime are indigent, are poor. So 80 to 90% of the accused are eligible for indigent defense. And so prior to this ruling, it meant that large swaths of individuals charged with crime did not have a right to counsel, and that changes significantly, obviously, with Gideon. It basically says that because it's a right, states are responsible for providing lawyers for those who are accused of crimes. And so, like in the state of Wisconsin, we have the Wisconsin's Public Defender's Office, and because of Gideon. Because if you can't afford an attorney, one will be provided to you from the state. It also improves the status of defense lawyers. That in the past, since defense lawyers came from the private bar, a lot of times defense lawyers were looked down upon because it was like, hey, you're just like trying to defend criminals. Today, for the most part, but if you ask Ketanji Brown, she was totally grilled in her Supreme Court hearing because she acted as a federal public defender, and the people on the Judiciary Committee looked down on that. But overall, the status of criminal defense lawyers has improved in the United States, because now it's not like, oh, you're helping out criminals, but really that you are in the front lines of assuring that due process is achieved and that everybody gets a right to criminal defense. Again, it gives us more confidence because when somebody gets the right to criminal defense, when they are convicted, we have more confidence that it was the right decision. I don't mean to go on, but if you're interested, there's a great documentary called Gideon's Trumpet, and it's about the challenges that criminal defense attorneys, public defenders in particular face, and how dedicated they are to making sure that everybody gets a proper defense. If you're interested in watching that video, drop me an email because I've got a link to it. My students watch my crime class, and I have a link to it. It's publicly available for the College of General Studies students. It's also, the case is unique because the writ of certiorari was presented in the Informa Pauperis, and also Abe Fortas, future Supreme Court Justice, represented Gideon at the Supreme Court. So after Gideon versus Wainwright, some questions continue to remain about the extent of the right to counsel. One question is, well, what kind of crimes does Gideon cover? Does it apply to everybody? And what the Supreme Court has said is that the right to counsel applies to what's known as the loss of liberty rule. In other words, if you are convicted of what you are charged for, and you can be incarcerated even for 1 hour a day, okay? If your conviction could result in your loss of liberty, then you have a right to counsel. And that you can't be sentenced to incarceration if you didn't have a right to counsel. That's the liberty rule. And so it's expansive in terms of the kinds of crimes that it extends to. Now, if a potential punishment for your crime is that you are never going to be incarcerated, then the right to counsel would not apply. It also applies to suspended sentences and juvenile cases as well. So a lot of times that, you might be charged with a crime, but then if you do certain things, your sentence is suspended. But then if you don't do those certain things, then your sentence can be that sentence could be enacted at that point. You had to have counsel during the process of getting that suspended sentence. And also it applies to juvenile cases as well. In other words, juveniles have a right to counsel if they have a loss of liberty potential. How long does the right to counsel extend? Through the first appeal. After that, it's up to the state. So the right to counsel is that you have a right to appeal your conviction. And must counsel be effected? Yes, indeedly doodly. If you're going to have counsel, it's got to be effective. And it's defined as, in the case Strickland versus Washington, which you will read about in your textbook. Okay, so that's it for the right to counsel. In the next lecture, we are going to be taking a look at the Eighth Amendment and the death penalty. Thanks for listening. I appreciate your time, and I'll talk to you again soon.